If I asked you right now, does your will control everything you own? A lot of people would say yes, but that answer would be wrong. At its core, estate planning is about three simple things: who's in control, when that control changes, and how assets legally move from one person to another. These are the three things you need to fully understand in order to fully understand wills and trusts. Hey guys, what's up? I'm Erin. Today, with this very comprehensive video, I'm going to walk you through what a will actually is, what a trust actually is, and what each one can and cannot do. For this video, as with all of my videos, the goal is education and understanding. Because once you understand the nuances, you can make better decisions that fit your life. Let's start with the very foundation. Assets transfer based on legal structure. Thoughtful. Legal structure is really the trump card here because assets do not transfer based on personal opinion or based on what feels fair. Legal structure is mechanical. It is a very rare situation where a court will come along and say, "Hey, can you clarify what you intended here?" And importantly, in a situation where someone passes away, there is no way to clarify what their intent was. So instead, the law comes across and it asks, how was this asset titled? Was there a contract and was there a beneficiary designation? That is it. These are the only three ways assets move at death. And once you understand these three different buckets, estate planning gets much easier. Number one, by contract. Some assets pass automatically because you signed a contract. This often includes retirement accounts, life insurance, or payable on death or transfer on death accounts. That is assuming you named a beneficiary, because when you name a beneficiary, you are entering into a binding agreement. So at your death, the contract executes and the money transfers directly to the named beneficiary. There's no court involvement, no reference to your will. And this is a very important detail. If your will says one thing and your beneficiary form says another, the beneficiary form wins every time. And that's why it's so important that you update your beneficiaries regularly, or that you at least check them to make sure the beneficiary is who you want it to be. Method of transfer number 2 is by title. The second way assets transfer is by ownership structure. If you own a property jointly with rights of survivorship, like many married couples do with their home or perhaps a joint checking account, the surviving spouse automatically becomes the full owner. Again, it does not matter what your will says. The title contract controls the situation. Again, this is a very mechanical process. For example, imagine you're in a second marriage and you own a home jointly with your current spouse, but your will says you want your share of the home to go to a child from a previous marriage. That clause in the will is irrelevant because the moment you pass away, the surviving owner, your spouse, becomes the full owner of the property. Ownership structure trumps testamentary wishes. And keep in mind here, no one is ignoring your will. This is simply how jointly titled assets transfer in the legal system. And if you don't understand this is how you can unintentionally create outcomes that you didn't want. Finally, the other way assets transfer is by probate. Everything else not covered by contract or by title falls into the third bucket. If an asset has no beneficiary designation, no survivorship feature, no trust ownership, and yes, we will circle back to trust later in this video, this becomes a probate asset. And probate is simply a court-supervised process of transferring assets at death. And here's the key distinction. A will only controls what falls into this third bucket. So, if you have accounts with beneficiaries, or if you have jointly titled accounts or property, they don't go through probate. Probate only oversees probate assets. So really, estate planning comes down to understanding which bucket an asset is sitting in. Now let's take a moment and strip this down. A will is a revocable legal document, and revocable simply means you can change it while you're alive. And a will has zero legal effect while you're alive. It can't control anything. It can't move anything. It literally just sits there. It only becomes operative at death, and its primary function is very simple. It directs the distribution of probate assets, and I really want you to hear that sentence again. It directs the distribution of probate assets. So this means with a will, you cannot avoid probate. In fact, a will is the very first step of a probate process. When someone passes away, their will is turned into the court, and this begins the probate process. So it doesn't avoid the probate process. It operates within the court system. That is its role. Now, here's what a will can do. You can name an executor. An executor is simply the person responsible for carrying out the instructions of your will. They gather your assets. They work with the court during probate. They pay final bills and taxes, and ultimately they distribute the remaining assets according to your instructions. So really, the executor can be thought of as the administrator of your estate. They make sure that everything actually gets done the way you intended it. A will can also name guardians for minor children. This part is critically important if you have minor children. A will is where you name who you would want to raise them should something happen to you. A will is the only place you can do this. So, if you have minor children, you need a will. It is non-negotiable. And a will also directs assets that don't pass by contract or by title, as we already said. In other words, anything that falls into this probate bucket. But just as importantly, here's what a will cannot do. It cannot override beneficiary designations or override joint ownership, avoid probate, reduce estate taxes, or provide creditor protection. And an important reminder, a will absolutely does not control everything. It only controls what falls into that probate bucket. Now, let me give you a simple example because this is where a lot of people get surprised. Imagine someone passes away and they have the following: a will that says everything goes to their children, a life insurance policy naming their sibling, and a house that's jointly owned with their spouse. Now, some people assume the will controls everything, but here's what actually happens. The life insurance goes to the sibling because the beneficiary form controls. The house passes automatically to the surviving spouse because the title controls. And the will only controls whatever probate assets are left. That's it. Remember, this process is mechanical. It's not based on what someone intended or what they meant. It follows the legal structure. If you want your assets to move the way you intend when you are no longer here, you have to understand the structure because the legal system will follow the paperwork, not your intention. Now let's talk about trusts. A trust is not just a document, it is a legal relationship. A trust exists when a grantor transfers property to a trustee to be managed for the benefit of beneficiaries. That's the structure. And here's the core concept. A trust separates legal ownership from beneficial ownership. In plain English, that means one person can be responsible for managing the asset while someone else benefits from it. A trustee has legal control. They manage the money. They make the decisions. They follow what is outlined in the trust. The beneficiary is the one who receives the benefit from the assets, whether that is income, distributions, or long-term support. This separation is the entire reason trusts exist because it allows you to create a structure on how and when assets are used. Trusts are about control over timing, continuity, managing complexity, and managing incapacity. And yes, when properly structured and funded, a revocable living trust can keep assets out of probate. So this means that the transfer would happen privately rather than in a public court-supervised process. Probate proceedings are public proceedings. Trust administration is not. And this privacy and this ability to have continuity with how you intend for your assets to be used is one of the main drivers for why families choose to set up a trust. There are really two types of trusts people usually encounter. A living trust is created during your lifetime. It can be revocable or irrevocable, and it can operate while you're alive or once you've passed away. So when someone casually mentions, "I have a trust," this is generally what they're referring to. On the other hand, a testamentary trust is different. It's created inside a will, and it does not exist while you're alive. It only comes into existence at death. And because it's created through a will, it still goes through probate. So, a testamentary trust does not avoid probate. It is born out of it. The real benefit here is control after your death. This can be valuable when someone wants assets distributed over time instead of all at once, especially for minor children or financially inexperienced beneficiaries. With all of that foundation laid, we can now talk about the comparison most people are trying to understand. A revocable living trust versus a will. A revocable living trust is created during your lifetime, and while you are alive and competent, it is still fully under your control. You can act as your own trustee. You can manage your own assets. You can amend or revoke the trust entirely. So, in practical terms, nothing changes in how you use your money day to day. But here's where the nuance comes in. A revocable trust can avoid probate, but only if it's properly funded. That means assets have to be retitled in the name of the trust or directed to flow into it. Creating the document itself isn't enough. Second, a revocable trust operates during incapacity. If you become unable to manage your affairs, a successor trustee can step in and manage your assets without court involvement. This is one of the strongest arguments for a trust because it provides continuity during your lifetime. Third, it's private. Probate is public, while trust administration is generally private. However, a revocable trust does not reduce estate taxes, does not protect from creditors, and does not remove assets from your estate. Because you retain control, the IRS still treats those assets as yours. So, a revocable living trust is about convenience, continuity, and administration. It is not a tax strategy. Now, let's talk about a will on its own. A will requires probate. It operates within the court system. It has no incapacity function. It only comes into play after death. It becomes part of the public record. However, it is simpler, less expensive, and often sufficient for straightforward estates. Estate planning comes down to choosing the structure that fits your life. There is also another category called irrevocable trusts. These involve giving up control of your assets and can provide tax benefits, asset protection, and advanced planning strategies. But they come with trade-offs and are used in more complex situations. Incapacity planning is also critical. If someone becomes incapacitated, there are generally 3 routes: court-appointed guardianship, power of attorney, or a successor trustee under a trust. A comprehensive plan often includes a revocable trust, a durable power of attorney, a healthcare directive, and possibly a living will. When these documents are in place, they work together. When they're missing, families often end up in court. Now, let's clear up some common misconceptions. Trusts do not automatically avoid taxes. Only certain irrevocable trusts may offer tax advantages. Trusts only avoid probate if they are properly funded. A will does not control everything. It only controls probate assets. Testamentary trusts do not avoid probate. Estate planning is about structure and understanding which legal mechanism controls which asset. There is one area where a will is not optional: guardianship. If you have minor children, only a will allows you to name a guardian. Even if you have a trust, you still need a will for this reason. Not everyone needs a trust. A will may be sufficient if your estate is simple, your assets have proper beneficiary designations, and you're comfortable with probate. A trust makes more sense when avoiding probate, maintaining privacy, managing multi-state property, planning for incapacity, or handling complex family situations. Think of it like this: a will equals death, probate, and public. A revocable trust equals life, incapacity, and privacy. Funding matters. Control equals taxation. Guardianship only lives in a will. Estate planning is about making one of life's hardest moments easier for the people you love. So, what are your thoughts? Do you have a will? Do you have a trust? What was your experience in getting them? Do you recommend that other people get them? I'd love to hear. I post new videos every single week. If you got anything at all out of this one, please give it a like. If you're new here, please consider subscribing, or if you know of someone who might get something out of this type of content, please consider sharing. I'll see you soon. Bye. How control? I've said it before, it does not protect you from creditors. Potential incapacity is important. Oh goodness, generally becomes public. I hit my microphone. Under a revocable trust. I think I said revocable weird. I don't want to give personal experience. It wasn't good. Wasn't good. What happened was unbelievable. One day we can get into it, but it was the worst situation. They still very well may go through probate. Oh my goodness, I'm falling apart here. Second marriage. Marriages.
What the heck?